First off, thank you to everyone for coming. My name is Curt Eastwood. I'm the Boone County Prosecutor. I have a prepared written statement, which I'm going to read. When I'm finished, I will take brief but limited in scope questions. First, I want to begin by expressing my deepest sympathies to the family and loved ones of Maria Florinda Rios Perez de Velazquez. This is a tragedy for everyone involved. And our hearts and prayers are with her family as they navigate this difficult time. I also want to thank the Whitestown Police Department for their outstanding work. Their investigation has been thorough and professional. Their continued cooperation and teamwork with the Boone County Prosecutor's Office has been invaluable as we move forward in this case. As prosecutors, we have a solemn responsibility. We cannot allow emotion to guide our decisions. Our duty is to examine the facts, apply the law fairly and equally, and ensure that justice is served without bias or influence. That is the only way the law can truly be just. Cases of this nature require a meticulous review of every detail and every piece of evidence. After a comprehensive examination, the Boone County Prosecutor's Office has filed one count, that count being voluntary manslaughter, which is to knowingly kill while acting under sudden heat as a level 2 felony. This has been charged against Curt Andersen of Whitestown, Indiana. At the conclusion of this press conference, copies of the charging information and the probable cause affidavit will be made available to you once it is unsealed by the court. It is vitally important for the citizens of Boone County to understand that our decision today in no way should be interpreted as a challenge to Indiana stand your ground law or a person's right to self-defense. We respect those laws, believe in those laws, and will uphold those laws. Based upon the particular evidence and circumstances of this case, we have determined that Curt Andersen's actions do not fall within the legal protections provided by the Indiana Stand Your Ground law. This case is not about undermining the law, it's about applying the law to the facts of this case, and that is what we intend to prove at trial. Curt Andersen remains presumed innocent, and until the state proves his guilt beyond a reasonable doubt in a court of law. This presumption of innocence is a cornerstone of our justice system and a principle that lies at the heart of a fair and just legal system. Finally, I need to address one critical point. During the pendency of this investigation, social media has circulated false and misleading information. This must stop immediately. It does not help the process. It does not help this case. It undermines the integrity of the judicial process. It spreads confusion, and it harms both the victim's family and the accused's right to a fair trial. One particular harmful claim was that this crime was committed by a police officer. That is categorically and absolutely false. Curt Andersen has no affiliation with any local police department. To our knowledge, he has never been a police officer, and there is no evidence of any connection to a law enforcement agency or personnel in Boone County. By spreading these falsehoods, you are undermining everything we work for every single day to ensure and defend in our system. Stop sharing rumors. Stop posting misleading narratives. Rely on official sources for accurate information. Justice cannot exist without the truth. At this time, I am prepared to take questions as both one thing I want to make sure everyone understands. As both an attorney and as a prosecutor, I am bound by the Indiana rules of professional conduct, in particular, Rule 3.6 and 3.8. 3.6 applies to all attorneys, and 3.8 applies to prosecutors in particular. These rules impose obligations to respect these rules and protect the integrity of this case moving forward. I will not discuss the facts, case strategy, or anything speculative in nature. I'm happy to answer questions about the process going forward and to related matters. And so with that, I'm going to remind you, when this is over, I will have copies of this written statement for the press. I'll have copies of the probable cause affidavit, and I'll have copies of the charging information. With that, I can answer your questions, but remember, very limited in scope about what I'm allowed to talk about.
When's the suspect due in court?
He's currently at the Boone County Jail. He's been booked in. The defendant, the court will then set the initial hearing date. At the latest, it'll be Friday. He's currently being held on no bond hold. At his initial hearing, the judge will set a bond pursuant to local rules.
It's been about 12 days since the incident happened. Take us through your process, and you said it was a careful examination. What you had to look at, go through to come to the decision.
Well, first, it was communication with Whitestown Police Department through the investigation. They would ask questions, we would ask questions, but we wanted them to take a thorough examination for them to complete it. They got most everything completed by the end of business on Friday, this past Friday. So with that, or a week ago Friday, I should say. So with that, we then started our review this past Monday. And we'll look at everything we had. So some of the things we have tape statements by witnesses. We have crime scene diagrams, crime scene videos, things of that nature is what we're looking at to make the determination. And then as a prosecutor, you look at the law and then you look at case law to support your conclusions.
What is the longest Mr. Andersen could potentially be incarcerated for if he's convicted of what he's being charged with?
Well, it's a level 2 felony, and as prosecutors, we can't really talk about potential penalties. So I'll tell you it's a level 2 felony under Indiana law.
Can you address at all what specifics in this case you say made it so it was a violation of law?
So what I'll say is first read the probable cause affidavit. Look at those facts, and what we're saying is that the stand your ground law does not apply in this case, as Mr. Andersen did not have proper information which would allow him to make the determination that he was reasonable in his actions.
Does the family have a victim's advocate within your office, and if not, is there any way that you can get them one as well as a translator?
Yes, so we have met with the victim personally. I personally met with him 2 hours. We have an attorney on staff that speaks Spanish, and they were present in the room. We will have a victim advocate for them, but when we met with them, that was not part of the process. But they have a victim advocate. They'll be meeting with the victim advocate, and our attorney who speaks Spanish will be meeting with them. So we do that in every case.
Thank you.
Yes, sir.
Did you utilize a grand jury in advance of the affidavit for probable cause?
No.
How, speak to the unusual circumstances of this case. How rare is this type of case in general? Because I know it's gotten a lot of attention.
Yeah, just talking in general, if you want, without talking about the specifics in this case, with the Indiana Stand Your Ground law, it is not something that's presented normally in Boone County. I can't speak for other counties, but in Boone County, this type of a case is very rare.
I don't know that you're going to answer any of the questions that we want to ask you, so.
Guys, I'd love to answer your questions, but I have a duty as a prosecutor that I cannot talk about facts that would get in front of the trier of fact, that would have a negative impact on the accused right to a fair trial. As a prosecutors, we have those duties, and we have to follow those. And I train on this topic, and I would be going against every single training I've ever done. And if you talk about specific facts and go into those details, There are public records in which you'll have. I'm going to confirm that the judges signed the motion to unseal, and I'll get you all that information. You can read it for yourselves.
Are you able to send that information over to us, or do we need to?
I have it. You have copies here, and then also anyone that's on that email list will be getting the same thing that's in here. So, because there are people that couldn't obviously make it today.
Awesome, thank you.
Did Mr. Anderson say anything when he learned about the charge?
I have Mr. Anderson is represented by counsel. I am not allowed to talk to Mr. Anderson now that he's represented by counsel. So.
Last question, once you looked at everything, was it very clear right away, okay, this is the charge? Was it an easy decision for you? How can you characterize that decision making?
It was thorough. It was thoughtful. Once we had all the information in front of us, once we looked at the law, once we looked at the case law, it became clear what the appropriate way to proceed with this case was.
Would you say this is one of the hardest cases you've had to come to a decision on, or?
No, and well, first, I want to thank everybody in the Boone County community, family, friends. I've had an outpouring of people, whether it's email, text, phone call, or someone just stopped me on the street saying, we're praying for you because we know you have a difficult decision to make. But honestly, it wasn't. I hate to sound cavalier about this, but it wasn't a hard decision. The hardest case in my life today is still death of Deputy Pickett. That case has been the hardest one because just everything that went into it.
You said that the standard ground law doesn't apply here. Where would that apply? Could you explain to people what that law actually covers?
Well, I'm going to read the law, so I want to make sure everyone hears it, okay? So in this scenario, when you have a dwelling, okay, we're only talking about when it applies to a dwelling. I'm not applying this to other scenarios, right? So under Indiana law, a person is justified in using reasonable force, which may include, including deadly force, against any other person, and does not have a duty to retreat if the person reasonably believes that the force is necessary to prevent or terminate the other person's unlawful entry of or attack on the person's dwelling, curtilage, or occupied motor vehicle. That's this kind of, that would apply to scenarios similar to this.
How did you determine that this didn't fall under that?
Well, it is our belief, and it's our contention that the person did not have a reasonable belief that that type of force was necessary, given all the facts that he had at that time.
Mr. Andersen, the lawyer went pretty quickly. Would you say that he was helpful in the investigation, or did they shut down immediately?
It's not, I really can't say yes or no to that question. It's not uncommon for people when they know that they are possibly being investigated for them to hire attorneys immediately. Through my career, it's very common for that to happen. So, yeah. So no, they've been cooperative. We've had communications with them since Mr. Relford made known that he's representing Mr. Andersen. We've been communicating with them, and I would deem the communication appropriate.